it now, and we will share it for anyone who may have missed, especially not the questions perhaps, but just the key parts. So that's an organization that I'm a director of, and we hold a sponsorship license. And so some of the practical aspects of what sponsors are going through, we're familiar with that. And also from the aspect of immigration law, we're also quite familiar with that. So that's what we are, that's the experience that I have and how I'm able to perhaps support sponsors. So today, we are still talking about sponsor guidance. Last month, we talked about reporting. So I'm not going to repeat that today, but that video is available for anyone because there's some really useful information on there, which can be quite helpful on what your reporting duties are, what things to look out for, what things to be really mindful of, because your sponsor license can be suspended for very minor, that may seem like minor things that you may overlook. And those are some of the issues that we're covering, taking a look at the guidance, but also taking a look at some of the case studies that we've been able to come across and see. So today we're specifically going to talk only about record keeping, because that's a big issue. So in the first webinar, we covered registration. We covered quite a bit in terms of the policies, how to apply duties and challenges and compliance. So today we're going to jump on to talking about record keeping, which might seem like something quite simple and quite small, but it is a very important aspect of your duties as a sponsor. And one of the things that the Home Office continually says to sponsors is to remind them that sponsorship is a privilege. It's an enormous privilege. It's a privilege, and with that privilege comes a lot of responsibility. So with that privilege comes responsibility, and that responsibility is for you to be able to comply with the law, ensure that you do what you are supposed to do, and to stay on the right side of the law, and to read the policies and to know. One of the things that I've learned is that ignorance of the law is no excuse. So the fact that you may not know something, or you may have interpreted something incorrectly, is not an excuse. The Home Office, they clamp quite hard, and they have what they call a light trigger approach. So they have a light trigger approach in the sense that they, if you do something which is an offense or where there's a breach, then they come down quite hard. So the sponsor duties, which are really important, are the reporting duties, the record keeping duties, general compliance with immigration laws, and not engaging in actions or behaviors that are not conducive to the public good. So as I've said before, we've covered reporting duties before, and today we're going to go on to talk about record keeping. And just to summarize on reporting, the key duties, just a summary of what you must report within 10 working days. If a sponsored worker doesn't start the role, if they're absent from work without permission for more than 10 days, if the contract of employment ends earlier, if you stop sponsoring a worker for any reason, and any significant changes to the worker's employment. And then within 20 working days, if there's any significant changes to your organization. So as I've said before, that we covered this in detail with a lot of examples in our last webinar, which is available as it is recorded, and it's available on YouTube. And to everyone who's registered, we will send that link if you want to just go through that. But definitely check in the sponsorship guidance, which is on the Home Office website, as to what the reporting duties are, so that you are well aware of them and you stay on top of it. So today I'm going to cover in a little bit more detail record keeping. And if you've got any questions around that, please may you pop them in the Q&A in the chat, so that I can be able to answer those. You can also post your questions anonymously as well. So I'll be able to answer those at the end. So thank you for that. So record keeping, that's what we're focusing on today. And believe it or not, that is a very big topic in terms of sponsorship, license suspension and compliance visit. It's really, really important. So the Home Office expects you to keep certain documents for each sponsored worker. So for each worker that you've sponsored, evidence to check that they've got a legal right to work in the UK and to do the work in question. So even though you've assigned the COS to them, you've helped them to apply for the visa, they've come to you. You still need to have on your system evidence. You still need to check that they've got their visa in question, that they have a right to work. So you still need to check on the Home Office system and print off the right to work check. Now, why that is very important is because of the date of the visa expiry. As you're aware, most of the biometric cards have an end date, which is the 31st of December, 2024, I think. So they have an end date, which is when biometric cards will be phased out. But people's visas will expire in 5 years, in 3 years, different times, depending on how long their visa is. So it's important for you to have the letter where they were granted their visa, which has got the expiry date. It's important for you to keep the right to work check that you've done on the Home Office website. It's important to keep their biometric, the card, their visa from their passport, their date of entry into the UK. All of those things are very important to maintain for each and every sponsored worker. And the date of arrival may seem like something that's quite small, or they're here, they've arrived. But the visa has got a start date of when they can enter the UK from. If they enter before, then that invalidates their visa and it can cause problems later on. So you need to ascertain that they've come in after the date on their passport, that they haven't come in too early, that they've come in on after the start date, because some people can slip through, and you record the end date, and ensure that you have a system on your, if you use Bright HR, if you use Excel spreadsheet, whatever it is that you use, it has to show that you've got evidence to show that you will be alerted to when their visa expires, either 28 days before or 3 months before, so that you're aware of when their visa will expire. So you need to ensure that you've got all of those documents. And when the Home Office comes, for a compliance visit, they will ask to see a sample of those. They'll ask to see your Excel spreadsheet. They will ask to see what system you have in place to evidence the legal right to work and evidence of the date of entry into the UK. And this is extremely important, even for your resident workers who have got student visas, who've got limited leave to remain, who've got other forms of leave like graduate visa. So it's important to have that for all of your migrant workers, not only those that you have sponsored. And we have seen people fall down on this in respect of not having all of the evidence. So it's something that is quite pedantic. It is something that is quite, it feels like they are just being fussy, but yes, they are fussy. They're extremely fussy. And they will just pick at things to say, why did you not have this? Why did you not have that? So one of the things is your contract of employment again. So when you need to keep a record of the contract of employment for your sponsored work and workers, and evidence again that they've signed the contract. You've signed them, they're dated, they have an accurate representation of their contract, of their contractual obligations and your contractual obligations to them. So you need to keep contracts of employment, ensure that they're signed, your offer letters, your recruitment processes. So the recruitment processes of where you advertised for your vacancies, even though carers are on the shortage occupation list, nurses are on the shortage occupation list, you must keep documents which show that you have advertised, you have got application forms, you have interviewed the people, and you've gone through your HR processes to show that the vacancies are genuine and what you have gone through all the processes that you are required to do. So the Home Office guidance says in Appendix D of the temporary workers and students guidance for sponsors, it states that you must retain a copy of any contract of employment or written statement of employment particulars between you, the sponsor, and the worker, which clearly shows all the names and signatures of all the parties involved, which is you and the worker, the start and end date of the contract, the details of the job that the worker has been contracted to do, the hours the worker will work, and an indication of how much the worker will be paid. So that is an important piece of evidence that you must keep, in addition to how you gave that person the job. What is it that you advertised for, and whether they met the requirements. So you have to keep that so that you can demonstrate to the Home Office that you've complied with all the rules. So with the sponsorship system, it gives employers a lot of leeway, it gives you a lot of discretion, it gives you the ability to do your own recruitment, issue your COSs, apply for visas. So you are essentially a mini Home Office. You have been given a lot of power and a lot of room. And you know that if you are given a noose that's long enough, sometimes you can end up hanging yourself because you've given a rope to be flexible with. But the reason why is because the Home Office trusts you. There's a level of trust. And because of that level of trust, like I said at the beginning, there's a level of responsibility that comes. So where anything goes wrong because of the trust, they come down hard. So they trust you and expect you to get on what you need to do, and they give you the space to do it. But with that comes a lot of trust. So if there's abuse of that process, that's why the Home Office comes down very hard on people. So I've said that you need to keep evidence of the contract of employment, the right to work, the national insurance number, which is on the BRP card. You must keep a record of that. You also have a duty to keep the history of the worker's contact details. And that is a very important thing to keep, because one of the duties that you have as a sponsor is to monitor migrants and to track them on behalf of the Home Office. So one of the ways that you monitor and track is by keeping a record of the address where they live and their contact details. So if the compliance officer comes to visit and they ask you for a record of your migrant worker's current address and details, and you give them And for example, they'll interview one of your workers. The first question they ask, what's your name? What's your date of birth? What is your address? And they'll give the address. What they will then do is cross-reference that address with your records. And where there's a discrepancy, you have failed to keep a record of the worker's contact details. And that is something that they also take seriously. And I've seen that in quite a few suspension letters. So it's important for you to ensure that you have a system in place that is robust, a system in place where you maintain a record and you keep a history of the worker's contact details and ensure that they are up to date. It may be that your workers do not cooperate with you, but it's important for you to show that you have a system in place. So you have a form where they fill in their address. What do you ask for? Proof of address. Maybe you ask for a driving license, bank statement, whatever it is, you ask for that and you record when you ask for it, when you got it. If they move and they don't tell you, you will demonstrate that you've got a policy in place where you ask for that. And then, of course, it's up to them to give that information, because some people won't want their employers to know where they live, or, you know, people can be funny like that. But as long as you've got a record that you've got a system in place, you've asked for proof. So if they've sent you proof of address, you've got their address on record, and it's from a certain date up to a certain date. So the Home Office will want you to show that you've got a method of keeping this valuable information and tracking your workers' details. You also need to keep a copy of the DBS check and a record of workers' absences. So now that is very important. I spoke about your contract, isn't it? That there is a contract of employment that you have, which has got your contractual obligation to the worker to pay them for 39 hours a week, or whatever, 40 hours or 37.5 at a certain rate. And if, for example, your worker has been absent from work and you haven't paid them because they were absent, and you haven't reported it on the Home Office system, you will be asked to account for those times. They'll ask, where was that worker? Why were they not paid? Then you'll say they were sick, or they had childcare problems. But what they want is for you to have a record of their absences. What efforts have you made to find out where they are? How have you been tracking them and monitoring them? So that is extremely important for you, to keep a record of all of their absences. If they're off sick, they're self-certified, they're sick, they've emailed you, you've got a record of that. They've sent a text message, you've got a screenshot of that. So it's important to keep all of those records. And it may be difficult because somebody may just text in the morning, and you may not be able to tally that with your main HR system. But it's very important for you to do that where there are gaps in their work routine and where there's absences. It's extremely important to keep a record of that. So that's very, very important for you to do. Please feel free to ask any questions on the chat, and then I will come back to them and answer. So record keeping, it's very important as to what you must keep. This is a summary, and I encourage everyone to go on to the Appendix D, where you can read all of the documents that you must keep. And my advice and tip to sponsors is for you to be actually, maybe get someone who does this job for you. If you're a director and you're trying to do your own compliance as well, get someone who goes through the list and ticks off, do we have this? Do we have this? Do we have this? For each and every staff member, and ensure that you have it. If you haven't got it, you request it. But go through the Appendix D of the sponsorship guidance, and it has details of all the records that you must keep, and tick and make sure that you've got that information. The other information that the Home Office expects you to keep, the secondment worker, we won't go into that, but evidence of how you've recruited the sponsored worker. They want to know the evidence of how you have recruited the sponsored worker. So they will ask you for evidence of that. Where did you post your adverts? What did your adverts say? And then what was your process? Do you have your interview records? Did you keep them? And what made you choose a certain person over another person? So they ask these questions to ensure that the vacancy was genuine and that you're not just using your sponsorship license as a way of assisting your family members to migrate, or your friends, or they want you to show that there was a genuine vacancy and you actually went through a proper recruitment process. So you need to keep that, the details of the adverts, the details of the process. That is very important for you to maintain copies of that, because if you do have a visit, they will ask you for that information. They will, so for example, if you've advertised on your website, keep a screenshot of that. If you've used Facebook as an advert, take a screenshot and keep a record of that. Indeed, keep your advert running on Indeed and show that. And they may ask your staff when they interview them, where did you see the advert? How did you apply? What was the process? So all of that is really important. And ensure that your adverts actually are reflective of the role that you are advertising for as a healthcare assistant. So how many months experience do you want? You want a clean police record? Do you want driving license? Your English language? They then put the salary details, ensure that it is very thorough and very, very detailed. And one of the things I've seen the Home Office pick on is that they said the advert, it didn't have a closing date for applications, so it doesn't look genuine. They've said that you don't have a record of how you shortlisted people, and you didn't keep a record of that. There's no record of how many people you interviewed or why you rejected interview other people. So the Home Office will expect you to keep a record of that and to provide it when they ask for it. And that can be one of the grounds that they use when they're coming in as a breach of your compliance duties. So where this comes from is from the Workers and Temporary Workers Guidance, which says you must keep certain documents for each worker you sponsor. Appendix D of the sponsor guidance lists these documents and how long you must keep them. And the documents can be kept in paper or electronic form. And you must give us, who is the Home Office, when asked, any documents relating to your sponsored workers or the running of your organization that we consider relevant to assessing your compliance with your duties as a sponsor. And they say then we might ask, for example, for details of your recruitment practices so that we can make sure that even though it's a shortage occupation that you're in, but that you've met the requirements of what the requirements of a resident labor market test would be. So they are still able to ask you. And if you fail to provide those documents, then they will take action against you. So that is very important for your international recruitment, your interview records, your advert samples, all of that is important for you to keep and maintain those records. Copies of salary details, pay slips for each and every worker. So I'll just go through the details of the pay slips and the copy of the contract of employment, and then answer the question. So yes, you need to keep pay slips, which seems like a really simple thing, isn't it? That of course you have pay slips, but the pay slips are very important documents where if you are having a compliance visit, the Home Office will use that as a way of assessing whether you are meeting your obligations in terms of providing sufficient hours and whether your vacancy was genuine or not. So they will look at the payslip to see how much people are being paid. Are they being paid the correct hourly rate? Are they being paid for the correct number of hours? Are you paying your national insurance and tax? And are you paying your pension for your workers? So the payslip is a piece of evidence that is used by the Home Office to assess whether you are meeting your obligations as a sponsor. So that is, and then when they have the compliance visit, they don't just ask for the payslip on its own, but they also ask proof that the money was actually paid into the account of the worker. So they may ask for your company bank statements or the individual's bank statements, or your own accounting system, which shows transfers. If you've got a back system or whatever system you use, that will demonstrate that that correct amount of money was actually paid into the worker's bank account. So they ask for 3 months wage slips, they ask for 12 months, they can ask for 5 years, they can ask for whatever they want. And that's why it's therefore important for you to keep a record of these, but also keep a record of absences, keep a record of a change in the worker's job, and report any changes where somebody perhaps has been sick and you've had to reduce their hours, where workers are on maternity leave, where there is a history of absence for mental health problems, whatever it is, keep a record and report to the Home Office where necessary, because this will then cover you if you have periods where they haven't been paid their full wage because of absences. So that's why it's important to keep a record of absences, because that will then tally with the pay slips. I hope this is making sense, because I feel like I'm talking a lot, but the pay slip is a wealth of information. If your staff opt out of the pension scheme, for example, you then need to keep a record of that so that you can explain that they've opted out. Your pay slips can also tell the Home Office if you're making unlawful deductions, if you're just deducting money from people for immigration or for something, and they will ask to say, why did you deduct that money? Do you have an agreement? What is the reason? And I read recently about 3 cases that were taken to court by Unison, where employers were not paying their staff according to their contract, because they perhaps didn't have enough hours, they were not providing the work, but they owed the staff the money because they had a contractual obligation to pay them for the relevant hours. So they left that employment, but they sued them, and they were helped by Unison, and they were able to recover the money that they owed the employees. So that's why contracts are important. Evidence of payments are important. Evidence of absence is important, so that when the Home Office is seeing what is happening, it's then quite clear for them in order to help them in assessing whether or not you are compliant and you are keeping up to date with your responsibilities as a sponsor. So the pay slips are like a field day for the Home Office, because when they look at them, they are reflective of what is actually happening and what is actually being paid. So it's very important for you to be able to keep a record of that and then to be able to show that to the Home Office. And lastly, the copy of the contract of employment, including a value of any allowances, plus the job description, skills, qualifications, and experience for the post. The Home Office would expect you to keep a record of that as well, because that is very important, especially where you have someone who is a senior carer, they're in that role, and they have, they're a senior carer, for example, but they're doing the job of a carer. So the Home Office will look at the job description, the contract of employment, the COS, and then put that against the evidence of the work that they've carried out. That do they carry out any senior roles? What is their responsibility? What are they doing? And then they ask that. So some employers may innocently see that a person has got really good skills in terms of office administration or project management, and promote them from being a carer to working in the office, and essentially being an administrator, but without changing their COS. And when the Home Office does their interviews, they ask Chipo, just a fake name, how are you finding it? What do you do on a day-to-day basis? And Chipo will be wanting to impress the Home Office because they've come, and she'll tell them, oh, I'm so excited because I've been promoted and I've got a new job and this is what I do. I help the director. I do the accounts because I was an accountant back home. And someone can innocently be telling the Home Office all of these things, and that is not aligning to their contract of employment, job description, or their COS. And then the Home Office will say, the job that you recruited this person for, it was a sham, the vacancy wasn't genuine, and so as a result of that, we are suspending your license, or you are in breach of your compliance duties, and you've lied to us, really. So, if someone is changing roles, then it's very important for you to change and update their visa and the conditions, so that it can reflect on the Home Office system that they're now doing a different job role. It's not that it's not allowed, it is allowed, but it's only that you have to ensure that you are compliant and you follow the rules, the letter of the law. So where there's breaches, there is the possible consequences are suspension, downgrading, revocation, and revocation circumstances. We'll go into that in detail on another webinar. But for today, just for record keeping, I'm gonna ask some of the questions, and I will then, let me just go through. There's someone who's anonymous who asked, if you don't have the hours, how can you pay the sponsored workers the hours? So if you don't have hours, can you pay the sponsored staff the hours they've worked only, as it's possible to lose hours if patients die or leave? Thank you for that question. And that is a very important question. It's a very, very important question, because I know that as an employer, you have the type of work that you do, it fluctuates. The demand fluctuates a lot. And most of the healthcare businesses were run on with 0-hour contracts, with employees who were pretty flexible. So now having full-time staff on 4 hours can present a challenge when there's a dip in business. So you have a contractual obligation to pay them for the hours, because you see, it doesn't make sense for someone who has migrated all the way from Asia, from Philippines, from Zimbabwe, from Zambia, thinking that they're going to be paid £21,000 a year and they're going to work 40 hours a week or whatever you have said in your contract. And then because clients have died, they're now working 5 hours a week, or they're getting paid for 10 hours a week. They cannot survive on that. So one of the things that the Home Office trusts you to do is to ensure that these people have enough to live on, enough to pay their rent, enough to survive, without having to work additional hours or look elsewhere. Their primary job is meant to have enough for them. So where you have too many staff members, and you have limited hours, it's better as an employer to change your staffing model, to perhaps have fewer permanent staff, and then still have the flexibility to take on when your demands increase, or when you have more clients, to then take on either part-timers or other people who are looking for hours, than to have, so an example, say you've got 50 people and you can only provide 40 hours for 20 of those people. It's better to let the 30 go and stay with the 20 that you can be flexible with, so that you are responsible for those. And then you add others using a different recruitment model where they're not your employees. Because one, you're liable for your contractual obligation, so you are liable to still pay them. And it's not for them as individuals to understand. It's not for them as individuals to know that people have died, so it is what it is. They need to survive. And the Home Office is trusting you to be able to pay them a living salary that they can afford to pay their bills and afford to eat and support their families, because they don't have recourse to public funds. They don't have a safety net. So in the interest of society as a whole, the Home Office is saying, we are trusting you to look after these people, so we want you to provide work for them. So if you find that you've over-recruited, or there's a dip, then you need to take management decisions, which sometimes can be difficult to take, but you may have to allow people to just look for employment elsewhere, encourage them to do that, so that they can find employment that can guarantee their hours. And then for you, where there's peaks and troughs, when it's down, at least you've got fewer people to pay than if you keep too many staff that you cannot pay. Because if those staff members, one, the risk is that if they decide that they want to say, I've got unpaid wages, they can make a successful claim against you. Two, if the Home Office comes in and you say, I didn't have hours, so I didn't pay them, that's not good enough for the Home Office. So you are on two fronts. You're exposing yourself to liability and to compliance action. It is actually better to say, I don't have sufficient work for you, so I'm going to have to let you go, and I'm going to give you the opportunity to look for another job. So it's better for people to do that, give them references, allow people to go. And, because you don't want to end up in a position where people can't survive. We have phone calls every day, every single day. We have phone calls from carers saying, my employer doesn't have hours. I'm depressed. I can't pay my bills. I can't pay for the car. My children are not going to school because I can't afford to send money home. I'm not working. I've worked 20 hours. I've worked 30 hours a month. So that is very risky. And so it's important. I don't know if any of you have heard of Helping Hands. Helping Hands had to cancel a lot of job offers because they over-recruited. So there's many people who had been offered jobs by Helping Hands, which is a big national organization, but they had to take that decision to say, we've over-recruited, maybe clients died, or they just didn't have enough work, and they had to let people go. So it's important for you to make those difficult management decisions, but look at your business needs, look at what you can afford to pay, and then make decisions based on that. I hope that's answered that well enough. Karen has asked, do these need to be wet signatures? They can be electronic signatures, they just need to be signed. You know, so if you use, if you email the contract to them and people can sign electronically, that's still fine. It doesn't have to be a wet signature, but there has to be a signature. So where there's an increase in salary, you can amend the contract, but you don't have to necessarily notify the Home Office where there's an increase. So for that new salary guidance, you can issue a new contract, but you don't necessarily have to notify the Home Office. Thank you. That's good. Thanks for that question. Clara Jomo has asked a question. Let me just go up there. If someone switches from student visa to COS, are they allowed to continue studying whilst they're working, or they have to give up their studies? So if they switch from a student visa to a COS, they can continue to study if their job allows them to, if they're able to meet their obligations for work and also study. So they don't have to give up their studies. So they will still have to pay foreign student fees, and they will still need to notify the university and that they've changed from a tier 4 to a skilled worker. So that the university will have to ensure that they notify the Home Office because they've cancelled the CAS and it's updated in their records. And then they have to ensure that they're working the contractual hours whilst they're studying. If they move to study part-time, or if their studies allow them to do that, then they're able to do that. But there's no bar on studying. So they are allowed to study, but they just have to ensure that they're able to meet their obligations as a staff member, meet the hours, and then notify the university so that they are aware of that, but they'll still need to pay foreign fees. So thank you for that question. So if someone has no hours, doctor's letter for being absent. So no, if someone has got no hours, then they need to take whatever steps they need to do. But if somebody is sick, then they can have a doctor's letter. So yeah, so if somebody is genuinely sick, then they need to have a doctor's letter so that it can reflect on the reason for the absences. They have to be able to demonstrate that. So yeah, I hope that answers the question. So yeah, so not if someone has got no hours, right? So if someone has no doctor's letter for being absent, okay. If somebody has got no doctor's letter for being absent, so they can self-certify for a certain number of days. And after that, you then need a fit note or a sick note, what used to be a sick note. So they would need to have that. Otherwise, you will have to report that as an unauthorized absence. So it's important for you, if someone keeps saying I'm sick, but they don't bring a letter from the doctor and you would then need to record that on your system and then also notify the Home Office. So you have to be careful where people don't have evidence of sickness. And they're just absent without a reason why they're absent, and it's unauthorized. You would need to ensure that you record that. Yeah, sorry, I had misunderstood the question. Word of mouth referrals for your recruitment process. It's good. It is a method, and it's a method that you have. What you must do is what can I say? Is record it. recorded how the person contacted you. So they would have to say, I was referred by my friend who works for them, and they told me to apply. So I applied online. You just need to then have your application form where it says, how did you hear about this job? You write word of mouth. So that's okay. And some people will have word of mouth referrals for everyone, but you've got a system in place for now processing those word of mouth referrals. And that's what they'll want to see, that you didn't advertise, you've got a good, your staff refer people, the people apply, they're interviewed. So you still have a system of how you got those people to be employed by you, rather than that you've just taken them on without going through any due process. Yeah, so stuff that you've gotten through a referral, I think I've answered that as well, because that's the same question. We're new to COS. Can workers be on 0 hours should, for instance, hours change due to clients dying and withdrawing a service? So no, with the sponsorship system, it is for, there is a minimum number of hours that people need to work. And that is to protect people from exploitation. So it's so important for the Home Office to show, to protect migrants from being exploited. So where people are on 0 hours, there is no guarantee of a salary, and people cannot live like that. So where you have British citizen workers or somebody who's not sponsored by you, who's a dependent, who does 0 hours, that's fine, because they can work at different places. But with this system, there's an assumption that you need the labor and you need them for a certain time to work. So you have to guarantee them that they are able to earn enough from you. So I know in the community, people will say, oh, well, they can always pick up shifts elsewhere, but that's not the intention of the Home Office. The Home Office wants you as the primary employer to be able to guarantee these people that they can live off the salary that you are paying them, and that they can survive, and that you are paying them what their COS said. So you cannot then switch them to 0 hours because you don't have work. You still have an obligation as an employer to pay them. So even if they're sitting at home, you have to pay them. So they will not accept that as a reason. So that's why it can be better to have fewer people so that you are able to pay them. If you then have, if clients die, or if you have a dip in your service for a long time, then it's better to let people go so that they can go and find employment somewhere else. So holding on to them when you don't have work for them, it only puts you at risk and puts them at risk as well. Yes, you can change job roles if the job is not on the shortage occupation list. So yes, that is possible. So there's another question of, how do we act as second employer to a main applicant who just has 20 hours to work elsewhere? And are we allowed to add more hours following the new policy that short we can work more hours without applying for a visa, as this is not, you see, this is a problem, Daisy, thank you for that question, because I see that on the share code, it's not reflecting that they can work unlimited hours. It still has 20 hours. On the Home Office website, it says they can work more hours until August. And that seems to be the statement that the Home Office have written. We've checked in the guidance to see where it's been updated. I have yet to find it, but I have seen it on the Home Office website. So I'm saying to sponsors that you can print off the Home Office website, the share code, and cover yourself as a statutory defense. But I don't know if it will wash, and I would err on the side of caution for most people. I'm a very cautious person, and I would say just employ them for 20 hours. Don't risk it for yourself. because of the right to work checks, which are not reflective of that. So you can act as a second employer. You would have to apply for a COS for them if you wanted to. So somebody can have 2 COSs and work 2 jobs. So if you want someone to work more hours, you can actually apply for them. So yeah, so that policy change until August, it's a bit, I wish it would reflect on the right to work. And I think it is something that one of the organizations is actually lobbying with the Home Office for them to change it, because we foresee that the Home Office can put employers into a spot of trouble later on when they're saying, why was this person working more hours? But one of the things that's really important to note as well is if you're a second employer and someone is working for you, they still need to be working at their primary place of employment. And then they can work extra hours elsewhere, but they still need to be employed by their primary employer. So it wouldn't be good enough for the person who holds the COS, who's the employer, to say they're working somewhere else, so they're fine. You still need to be employing them and guaranteeing their basic salary, because you've told the Home Office that that's what you're going to do. So they hold you to your word. And the risk, like I said, is if you then have a compliance visit and you've got 6 months pay slips where you haven't paid anything, it then becomes a problem. Yeah. You can promote your care worker to a registered manager. It's on the list. So you know the SOC code list, yeah. It's not just for the shortage occupation. So there's the standard occupation code. So there's a list of every occupation. So registered managers are there. As long as they've got their qualifications and their experience, then you can apply for a specific COS for them using the right code. And even though it's not on the shortage list, it is on the list. So it's you can still apply and promote somebody to management as long as they meet all the qualifications and you justify how you've recruited them. So where it's not on the shortage list, we do have to go through the interviews and still keep a record like you would anyway, but ensure that justify that they've got the right qualifications and you've employed them whilst they're waiting for their registration or whatever it is. So yeah, I think I've answered that one for you. So if somebody's asked, can I ask staff to move on due to lack of hours? Yes, I think it's probably better for you to do that. I think I've answered. So where case of hours fluctuate, keep paying your staff their monthly wages, and then of course they can work elsewhere, but you need to ensure that you keep the record of you are paying them what you're supposed to pay them. So the people who've lied to you that they are drivers when they don't drive and they're struggling to meet the hours. So, you know, where you misrepresent in a job application and an employer has got a specific request, which is why it's so important to have your job advert, your contracts, your offer letters. What did you say to them that you need? And it might seem tough. I think I've spoken to some employers and said, if they're not meeting the requirements of the job, and you find it difficult to be able to then get them to perform their role without driving, it's then a burden on you as an employer. It's a problem for you. Encourage them perhaps to apply for jobs in a hospital, apply for jobs in a care home, apply for jobs anywhere else where they don't need to drive. Because if you're running a company that does domiciliary care and you need drivers, by now trying to somebody has misrepresented to you. So you need to deal with it in terms of your employment law and your processes in HR. What do you do when somebody has lied on an application form about anything? So I think you would have to take steps as an employer to deal with that situation, because somebody has told you qualifications that they have for a job, which they don't have. So even if you have somebody who's lied to you that they wrote the English, maybe somebody else wrote it for them, and they can't speak English, they cannot communicate with the clients, they cannot perform their role. And you question the authenticity of their certificate, you would then have to take steps to speak to that person and go through your processes in terms of your HR procedures, so that if it means you have to let them go, then you have to let them go. But it's difficult for you to be able to, and don't think they'll thank you for keeping them on when you're not giving them hours. They'll be very angry towards you. But they've, if they've said they can drive and you needed drivers, I think it's important to make that clear. I've always said you need to make it clear from the interview, from the recruitment, from every stage. You need to make it clear what you require as a business. And so to make your business work, there's certain things that you require. And if one of them is for people to drive, then you need to make that clear. Yeah, so I think hours is a big problem, hey? And thank you for somebody else who has answered that if the contract states 40 hours, the employee should be paid 40 hours, regardless of whether a client has died or not. Okay. Right, great. Thank you for that. Since being granted our license, we've been inundated with emails from applicants. Is it enough? Yes. So that's evidence as well to show that you haven't had to advertise, because what will people do? They will look on they actually watch the list of who are the new sponsors and they apply. So that's fine. That's okay as evidence. Right. So what is our time? Our time, yes, our time is up now. And so some of the other questions, I'm going to record them. I'm not going to be able to answer all of them. And I'll send a recording. I think some of them we have answered before, because some of them were repeating, but we'll send out a recording of this webinar to everybody who's registered, and we'll have another one next month. There is another event, which is a meet and greet, which is June the 17th, and we'll send out details of that for sponsors. It's so important for everyone. This is a new area for most people, and it's an area where it's so important for you to network with other people, to work through problems together, and to support each other. So I'm going to, some of the other content on there, I'll do it in other webinars, but for today, I think that's it. But just in conclusion, take compliance seriously, please. A sponsorship license is good to have. It's useful for the business. It's amazing, but it can be lost just as easily. Read the guidance yourselves and the appendix, have mock audits, take advice. And we offer services where we help businesses to apply for sponsor licenses. There were some people who don't yet have a sponsor license. We do compliance checks virtually. We do on-site mock audits, but we do limit our travel to the West Midlands. For others, we do it virtually because it's a bit difficult for us to get around the whole country. We help people prepare for inspection. We respond to queries following suspension. We do some judicial reviews and private meetings just to go through some of the queries. So if you scan the QR code on there, you can visit our website and contact us if you need any of our services. So yeah, thank you very much, and thank you for joining, and hopefully we'll see you next month. We will share out a recording for you to just go through. Have a great day, and thank you. Hi, Tulia Marketing, could you do me a favor, please? And there's some questions in the Q&A that I didn't answer. Do you mind just downloading for us so that we can just send them? I'm not sure how to get that information. Thank you. Great.